All right, team, thanks for coming back and rejoining us for the second half of the contracts chapter lecture. And because everyone was so attentive and such a good trooper, I'm going to do us all a solid and make this lecture pretty short. So, in the first chapter, we talked about really what is a contract. Remember, a contract is a promise or set of promises between two or more parties that exchange both benefits and obligations going to both sides, and the law will enforce that remedy that's listed in the contract. Now, if there is some sort of ambiguity or a dispute, then the parties very well might choose to file a lawsuit in court, whether it be federal or state court, based on the claims, in order for a resolution to be figured out for them. Or they could use alternative dispute resolution like binding arbitration or mediation. Remember we encountered those in Chapter 4. Binding arbitration is pretty much the same as going to court, except it's done privately between the parties. They both kind of consent to the authority of someone who's acting as a judge. It's much cheaper and much quicker because the court system is pretty jammed up with lawsuits. Or mediation is where the parties might get together with someone who's a neutral party and try with their help to figure it out. So anyways, we will go ahead and jump into some examples from the field of contracts in the workplace involving here coaches. But very well, these contracts have the same elements as most any employment contract: offer, acceptance, consideration, legality, capacity, but they're just of a specific type. So we're going to breeze through. As you can see, it's after hours. I'm not wearing a jacket anymore. Very well might be losing the tie soon. Who knows how crazy it might get in here. But we're going to jump right into it right now. And as you can see here, we've got my best friend, Coach Jim Harbaugh from the University of Michigan, who's going to be one of my assistants for this lecture, as well as maybe some of you are familiar with this other gentleman, Kevin Sumlin, who is the head football coach at Texas A&M University, College Station. All right, so coaching contracts. Right off the bat, we need to talk about what are the differences between what are called at-will employee contracts versus multi-year employee contracts. So very intuitively, at-will contracts are those contracts for employees who can be fired or quit at any time. It's at their leisure. At-will employees make up the majority of the workforce, and that means that either the employee can quit or the employer can fire that person for any reason at any time, so long as the reason is not discriminatory. So we'll talk about discrimination in the workplace fairly soon, but in terms of contracts and the length, it's good to get that out of the way. Pardon the Starbucks. When are these at-will contracts appropriate? Well, traditionally, people who are high school coaches or high school employees, athletic trainers, managers, coaches, they very well might be at-will employees, meaning they can be hired and fired at any time, so long as it's not discriminatory and they can quit for any reason. Now, multi-year contracts mean that they are guaranteed employment so long as they don't breach the contract for a set period of years, usually 3 to 5 years, because the expectations are higher for these types of jobs, such as college or professional coaches or higher up more senior officials or administrators. And the market sort of establishes this expectation based on what is the normal course of operation within that field. Also, traditionally, a more successful coach can extract more guaranteed years of employment from the employer if that coach or administrator or trainer is successful and that their services are unique. So I'll let you guys drink this in. If you want to take a look at all these, you can press the pause button. But for now, these are some typical clauses that are come up in many coaching contracts. Many of them have to deal with benefits that are offered to the coach. And in this era of expanding commercialism within college athletics, we're seeing even more fringe benefits clauses being added to contracts. But for us, what is going to be most important is the key contract provisions. How long the contract lasts, the term, the length of employment. The duties and responsibilities of that coach or administrator. What do they need to do? What are they getting for their pay? Termination of employment. What constitutes an event where the employee is going to be fired versus what is an event where the employee cannot be fired? And we're going to talk about concepts of cause and not for cause, and whether or not something falls under one of those two designations will determine whether or not that employee continues to be paid even after they walk away. Of course, we got compensation. So we've got our little pyramid right here that shows a traditional salary structure, and then incentives that go along with compensation. And we'll also talk about some other provisions that we discussed somewhat in the last half, the first half of the chapter, liquidated damages clauses and a couple other clauses. Fun! Yay! All right, flying through. Duration of employment. Like I said, usually it's a number of years, 3 to 5. So here's a typical example. So the term of this agreement shall be for a period of 5 years, commencing on X and ending on Y. And then the university or the employer usually negotiates the right to extend the contract for 1 more year. That's called an option contract. We often hear that in professional sports contracts. And a specific number of years provision is something that's often negotiated. All right, so now we're going to talk about rights and responsibilities. So a coach's duties, as the slide says, has really dramatically changed over the years. Maybe when Dr. Spaniel or Dr. Bonnet, hopefully you don't tell them I mentioned this, but when they were coaches, perhaps their duties were limited to just on the field coaching and recruitment and really overseeing your players. But nowadays, the duties and responsibilities of coaches are pretty massive. These coaches often act as CEOs of their sport or even goodwill ambassadors of the university. And because of that, those duties are just very comprehensive. Duties for that coach or administrator could be tied to the attendance figures for who comes to watch the games, or trying to drum up publicity for the institution, working with development to extract monies out of boosters. Maybe you go on a booze cruise in the Caribbean that's full of boosters. And try to pump them for money, so long as it doesn't violate NCAA rules. Compliance matters. You've got responsibility over the team as well as the coaches and other staff, other operation staff. So it's pretty comprehensive. And so let's take a look at a couple of examples from Professor Sumlin and Professor Harbaugh, who are my guest lecturers today. So, in fact, let's pretend like I actually know what I'm doing here. We're going to do all like that, because I'm awesome. And then we're going to take a look at Kevin Sumlin at a glance. So Coach Sumlin, he's getting a base salary of $5 million. Length of contract is 84 months. We got some other awesome little tidbits here. But if you actually look at his contract under duties and responsibilities, let's see here, duties. So you look, it says the duties of Sumlin shall include those duties customarily performed by a head football coach at a major university, as well as related to tasks which which may be mutually agreed upon by someone and the director, hopefully the athletic director, not some other director. Someone shall perform all prescribed duties subject to the provisions thereof and pursuant to the orders, advice, and direction of the director. Someone shall be able to hire and terminate all of his assistant football coaches with all salaries and terminations reasonably approved by the director in advance. Someone shall at all times faithfully and to the best of his ability, experience, and talent perform all the duties that may be required of or from someone pursuant to the expressed and implied terms thereof, including adhering to the university's allocated budget to the reasonable satisfaction of the director and in such manner as to bring credit to the university. I'm already falling asleep here. Now let me ask y'all a question. Does this seem pretty specific in terms of the duties, or is it lacking in details? Now, if you say it's lacking in details, I might be inclined to agree with you. Someone shall include those duties customarily performed by the head football coach at a major university. Is there any ambiguity there? Could there be something that could be open to dispute in terms of interpretation? Maybe. Or maybe they did this on purpose. What do you guys think? Do you think that the university and someone left this very ambiguous? It certainly says down here in 2.3 that he will not publicly endorse any political figure or cause, engage in any business transaction or personal action, or appear in any radio or television programs other than the form of public media that may cause discredit to the university or system, blah, blah, blah. Do not violate NCAA rules. So there's some more specificity here. Well, what does old Jim Harbaugh have to say about this? Let's see if I can... Oh, there's Jim Harbaugh's contract. All right. Jim Harbaugh's responsibilities. So now here you can notice a difference. It's more detailed. We've got 3 separate paragraphs by my count. We've got recognition of duties, so it shows that he is going to generally perform to the best of his abilities, and he reports to his boss. Okay, that kind of sounds similar as someone. But, we don't want to do that. But general duties, during the period of which the university employs the head coach, he agrees to perform all duties and responsibilities attendant to the position of head football coach as set forth in this agreement, subject to the overall supervision of the athletic director in compliance with university rules. He has so that here, just in the general duties, it says the head coach shall have primary authority and responsibility for supervising, evaluating, recruiting, and training, and coaching student athletes to compete against major college competition. Blah, 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 blah. Right there, it's more specific. Now, it even has specific duties and responsibilities. So specific duties down here. So coaching decisions, strategy. I know it's not strategy, but our president once used it, so I thought I'd bust it out. Strategies, practice, training, selection. Head football coach shall use his best efforts to comply with the academic and admission standards. Good conduct and enforce good conduct on and off the field. Just a litany of more specific duties. So you look just between someone's and Harbaugh's contract, and there's a difference in the level of specificity. Boom! Look at that. So you just look at these 2 contracts, and you can see that not all contracts are the same. They're written differently, and it's more likely that if a dispute ever arose between Sumlin and Texas A&M, that it could lead to potential litigation because it's not specifically spelled out what his duties are versus Harbaugh in Michigan. It's pretty specific. All right, so this is a great segue into the notion of termination for cause versus not for cause. So for cause, as defined in the textbook, is a failure to comply with some basic fundamental tenet of your contract. You will see language in many contracts, especially contracts of this nature involving coaches or higher ups, that it will say what constitutes a breach for cause and what is the remedy. So the big thing with for cause is that if a coach or an employee violates their contract and is terminated for cause because that violation is specifically listed under for cause, that means that the organization does not have to pay the individual who they fired the duration of the money that would be owed under that contract. So things like failure to perform basic duties, knowing violation of legal rules, violation of state or federal ethics laws, things that hurt the reputation of the organization, like convicting a felony, all these things are grounds for termination for cause, so long as that type of language is inserted into that contract. So let's go back to Professor, we don't want to do that, let's go back to Professor Sumlin and Professor Harbaugh. Boom. All right, let's go. Duties. Athletic Department investigations, payments of benefits. It's a lot of stuff. Termination and suspension. Dun, dun, dun. The university shall have the right to suspend someone for a period not exceeding 90 days without pay or terminate this agreement prior to the end of the original term or any renewal if there is, quote, cause. So here we are right into the cause section of the contract. So cause means conviction of or plea of guilty or nolo contendere. Nolo contendere is a legal term of art in criminal law, which basically means, does anyone know? Hands? Hands? Sarah? Right. It means no contest. You're pleading no contest. So Sarah gets extra credit because she actually answered. And if you think that there really was a Sarah here, then I guess I'm not the only one who's crazy. So if there is a conviction or you plead no contest to any sort of criminal act that constitutes a felony or engages in similar conduct bringing the university or system into disrepute. Notice how disrepute is not defined, and there could very well be a dispute over the definition of disrepute. So this really harkens back to the Richard Mendenhall case or the Louisville versus Duke case because disrepute is not defined. We've got some other stuff about engaging in or knowingly supporting or tolerating a major violation of Constitution, bylaws, blah, 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 the SEC, NCAA, refusing to perform duties. You guys get it. So then we go to B, which is interesting. I don't see this that often. It specifically says the football team's wins or loss record during the term shall not be sufficient cause for termination. So that straight out says that you can't fire someone and refuse to pay him just because he's not winning enough games for you. So I imagine that that clause was negotiated by someone. Termination without cause, therefore, the university shall have the right to terminate this employment agreement before the expiration of its stated term without cause. Termination without cause basically means that you need to continue paying my man. Keep getting paid, Kevin Sumlin. Exactly. So that's the clause that discusses termination without cause. So damages upon termination by university without cause. Okay, here's the terms of the payout, and I imagine that university will pay. Yes, sir. Okay, that's all right. Termination by Sumlin. So these situations where if it's a termination without cause, termination by the university, or termination by Sumlin, these could be construed as liquidated damages. In fact, right here, lo and behold, we've got the phrase liquidated damages. Remember, from the last part, or the last lecture in the first part of Chapter 4, liquidated damages is not a penalty, but instead it is an agreed amount of money that's negotiated between the parties to reflect the amount of potential injury that one of the parties who is not engaging in that conduct would suffer. So it says that if someone walks before this agreement has been completed, he's going to pay the university $5 million in liquidated damages. Now, usually it's de-escalates, so I'm not quite sure. Let's see here. Okay, yeah. So if he should terminate the cause prior to the last game of the 16-17 season, which is this year, he'll have to pay $5 million. Now, I imagine that it's going to de-escalate as he completes more of his contract. So I don't want to beat a dead horse here, but we would see in Harbaugh's contract that there's going to be a termination language in here, and I really don't want to hunt and peck through it, but I guess it's happening because we're right here. Termination without cause, so it says may terminate prior to the expiration of the term. It probably says that he's going to get all of the money, and this is going to be dictating how that goes down. Termination for cause, so failure by the head coach in any material respect to perform the material services required under this agreement, or breach in any material respect of any of the head coach's material duties. There's a lot of material stuff and a lot of material words in that clause. The university shall not be required written notice. Blah blah blah. So here are some of the things that are caused right here. Again, nolo contendere to any felony, offends public decency, morality, failure to promptly report athletic director a violation of governing rules. So the only question that I have here is what type of event falls under a material duty. So it very well could be that somewhere in this contract a material event or a material breach is defined, but if it's not, then that creates a problem. So okay, this brings us to an issue this brings us to a point where we can talk about the Jim O'Brien case, which was one of your discussion board questions. Remember, Jim O'Brien was fired by Ohio State as head basketball coach because he committed an instability violation. He eventually reported it, but did not report it at the time, and filled out paperwork saying that he had reported all the violations and he had lied, and he sued for his wages because he said that he should not have been hired or fired for cause. He was fired actually not for cause, he was arguing, and therefore he deserves the money. And the court actually agreed with Jim O'Brien. Surprisingly, you would think that a failure to report a violation, in fact lie about it, would be grounds for termination, but the court gave the rationale that, well, yes, he breached the contract, but it was not a material breach of the contract. And here the court gives us the standard by which it judged or defined what a material breach was. And it would be any sort of violation of the contract that destroys the ability of either party to actually perform the terms of the contract. So if Jim O'Brien did something that completely frustrated the ability of Ohio State to continue in executing that contract, then that would be a material breach. But since O'Brien could still continue to coach, even though he did not report a violation and lied about it, that means that it was not a material violation, and by Ohio State terminating him and walking away, they breached the contract. Ohio State could have punished him somehow, suspending him or fining him or done something else, but they didn't. They chose to fire him. They could have given him a buyout. They could have given him you look at this slide, there's typical ways if you want to punish someone but not, but it doesn't fall under cause, you could negotiate a buyout with the coach where you're going to pay that coach a lesser amount of money to walk, or a reassignment clause, which is in your homework, which is basically needs to be negotiated into that contract that says the university or the athletic department can relieve a coach of their duties and reassign that person to another position in the university, maybe as an administrator or as a teacher, but they don't need to fire them outright. And why might the university want to reassign the coach or administrator without firing them? Well, maybe it would cost too much money to continue to fire them, and then can hire someone else and pay them a salary while still paying the salary of someone who was fired. So this kind of brings us to a buyout or liquidated damages provision that might had been helpful, although this is for termination by the coach. But here's an example here of a liquidated damages or buyout. Again, the coach is paying a certain amount of money because the coach is walking away, and this brings up an interesting case involving Jerry DiNardo, who was the coach at Vanderbilt and then took a job to go to LSU, and he was found liable for a higher amount of money than what was due to him, or what was due to him under the contract. And the reason for that rationale was that there was a liquidated damages clause in that contract he had signed with Vanderbilt, and it was a high number. And that high number reflected not just the amount of money that the university would suffer by not having DiNardo's services for the duration of the contract, but it also reflected the total loss that the university and athletic department would suffer by the loss of their brand and loss of their momentum if they had to replace the head coach and start over. So that's also something to consider for a liquidated damages clause. Now, in terms of compensation, this is the fun part. This is where the coach negotiates what sort of benefit, the dollar amount, and what sort of benefits he or she gets. So salary, a common way that this works is that the university itself, the athletic department, pays a base salary, and then someone else, usually boosters or it could be another entity, pays the coach a much higher amount. So with oftentimes coaches are paid a small base salary by the university, but then the bulk of the salary comes from the coach's media duties. So going on the weekly television show or radio show, or doing something with apparel or sponsorships. So we have an example here for the base salary for Jim Harbaugh. It's compensation for his services performed under this agreement. The head coach shall get $500,000 a year, but then you can see he'll get an additional $4.5 million by what's going on in his television, radio, internet, public relations, promotional activities, personal appearance. So that's pretty sweet. So you can see that the vast majority comes from his additional duties that are outside the university. Or outside the athletic department. Incentives. Oftentimes a coach will get a bonus by winning certain milestones, so a league championship or a national championship, etc. Academic ones, if your APR is higher than a specific threshold. Ticket sales, and then there's a pool of money the coach usually gets to share with his or her assistant coaches. So here's the example with Harbaugh. He gets $125,000 if he plays in the Big Ten championship game, and he gets an additional $250,000 if he wins it. You can go all the way down here. Coach of the year, all that great stuff. Fun. I want to thank you guys for being good sports and for completing both lectures. Make sure if you have any questions about anything or want some more examples to give me a shout. I'm available via email, or you can come and see me, or you can give me a call. All right, team, thanks a lot, and I'll see you next time.